patent cases, it never really worked. But in the last 6 months, a year, there's been a big improvement, and I'll touch on some of the factors around that in a moment. What I think makes a big difference is that we do actually have patent trials in the UK, and they happen within 6 months, 12 months, 18 months, depending on the complexity. So the fact that a patentee knows that, in fact, he is going to be able to pursue his case through to judgment, obtain an award of damages, I think influences, to some extent, the way in which interim relief is granted in the first place. So I think although one of my colleagues here will be talking about, reminding you of the basic common law principles in India, it's a slightly, perhaps, broader approach or more balanced approach in the UK, because the judges know that in the end, the trial will be available, and therefore the issue of whether or not to grant an interim injunction is perhaps less stark.
We do understand the shortcomings of our judicial system, and in that regard, interim relief played a very critical role. Coming back to the criteria of the prima facie case, a very tall task to be met. What does constitute a prima facie case? We had the Supreme Court laid down a case in the case of Midas Hygiene, where the Supreme Court said that in case your mark or a copyright is registered, an injunction should follow. But is that the only criteria required? Also, the Supreme Court did say that delay would not defeat an injunction. So we have really good standards set by the courts in India for granting an injunction.
The interim injunction, I think, is very important for any company which is, whether into an FMCG sector, whether it's an automotive company, whether it's a pharma company, any company, or whether it's a liquor spirit company. Why an interim injunction very important? That which Jan was talking about, those damages, that damages cannot be quantified. It's a brand dilution. It's actually a brand dilution which happens. Companies which have global presence today, they are manufacturing global brands today. Those brands suffer brand dilution apart from economical loss which happens. So what normally the strategy is suggested, you approach Delhi High Court, it can be a Bombay based company, or it can be a Hyderabad based company, or it can be a US based company. You approach Delhi High Court, take a stay against that person, go and convince the investigating agencies over there to conduct a raid. Why? Because then only investigating agencies will have that power to understand that yes, there is an infringement of trademark or copyright or design. You see, there are a lot of infringers like this or defendants who are manufacturing products where the trademark is also the same, where the copyright is also the same. The artistic work, the color combination, the layout, the scheme, everything is same.
Just to conclude the discussion, I'll put forth few points from the industry perspective, that how do companies see it, like as an in-house counsel, how do I see this entire stuff about IP and enforcement? At the moment you go outside the shores of India, right, and your markets are outside India, IP is something that you cannot ignore. You have to be cognizant of its presence and live by the standards and the business customs that they are done there. So for the companies who have overseas business, this is absolutely an important topic for us. The second important point, or perhaps something that I thought would, there are certain inherent benefits that our system gives, right? That is the low cost of the litigation and the low cost of filings that our system offers, right? And that and I'm sure many of you who are doing overseas, if you do a comparison, Indian costs are still very affordable, which also, plus the law that has changed over a period of time, though it is very modern, but also it offers certain inherent benefits, like it avoids patent trolls to kind of come in, which is one of the menacing phenomena that's happening in the West. In India, it's unheard of because of, one, the low litigation cost, and the second in terms of the the whole provisions related to software licensing, which is not allowed under the Indian acts, and plus in terms of the compulsory licensing regimes with the courts, and recent Madras High Court is a good example. So I think the Indian system offers certain benefits, and it is, but at the same time, it could match international laws with the recent amendments and more coming in the pipeline.
Brought to you by Legal Era, India's #1 legal and corporate awareness magazine.
IPR Conclave 2012, the two-day interactive seminar on the emerging trends in IPR, was inaugurated by Justice P.N. Sri Krishna, and he had this to say about IPR, or the intellectual property right.
This is a right which cannot be touched by a thief. It cannot be taken away by a robber. It cannot be subjected to tax, though I must confess that our chaps have found out ways of taxing it too. It cannot be taken away in a partition suit. It cannot be taken away by your enemy. It remains with you. Why? Because it is knowledge, and something that is knowledge is internalized.
Earlier, Depolina Pertap of Wokhart welcomed the audience to the event.
In the past 5 years, especially during the post-global slump, the importance of IP has grown phenomenally, with some new laws, judgments, international agreements, and protocols actually getting implemented meaningfully, giving rise to new challenges for IP creation and protection. Intellectual property today is the lifeline for any company. We have seen several cases where companies have scaled heights through the single most effective tool, intellectual property.
The purpose of the IPR Conclave is to educate people on the importance of intellectual property in today's world. As you know, intellectual property has assumed great importance because the entire economies of the world are dependent on the value that the people are creating in terms of new innovative products and services and new technologies.
IPR is becoming increasingly important, and all companies value the importance of those rights, and so I think it's topical to look at it now, and particularly look at the international perspectives and challenges and an analysis around the topic.
Well, I think that I've been coming to India for many years, and when I first started coming here, IPRs weren't really regarded very seriously as important things to business. I think because the market was very protected, and there were only a few firms that actually did anything to do with trademarks, patents, that kind of thing. But I think over the last 10 years or so, you've got some very good specialist firms here. Awareness is growing, businesses are becoming more interested in and understanding the fundamental importance of IP rights.
It delivers one important message, and that is IPR rights are required for the economy. And secondly, it also helps in bringing together minds of the industry plus legal practitioners to update with the latest developments and to discuss it in a forum like this.
Now when we are talking of a globalization and the whole world becoming a one village, it is the IPR protection is most important, because in India still today IPR's intrinsic value, or what, like a brand which if it is created, what it can help the company, has not been yet better understood and not better followed.
Brought to you by Legal Era, India's #1 legal and corporate awareness magazine.